All right. All right. Thank you all for attending. My name is Kim Weber. I'm the Executive Director of the Ethics Commission. And I'm grateful that you all have showed up here today for our training. We are going to be talking about the Ethics Act and the Open Meetings Act this morning. The topics of the Ethics Act that we'll cover include using public office for private gain, solicitation and gifts, the name and likeness provision, prohibited public contracts, voting and recusal, conflicts of interest, and employment restrictions. So the first and the broadest provision of the Ethics Act prohibits public servants from using public resources, including time, supplies, premises, subordinate staff, or prestige for someone's unlawful private benefit. And there are a couple exceptions in the statute, in this provision. The first is there's a de minimis exception, which means if you use a very little amount of public resources, it may not rise to the level of a violation of the Ethics Act. The danger in relying on that exception is that there's no clear line as to where and when more than a de minimis amount of resources has occurred. So if you use public resources for your private benefit or for someone else's, you are at risk of violating the Ethics Act. Another statutory exception is for business travel-related bonus points, and it's written right into the statute. And it states that if you are traveling for your public business and you're staying in a hotel or taking an airplane, or even getting gas. And if you use your personal rewards card to collect bonus points, you may keep them and use them for your personal use. But be on guard, that exception does not apply for non-travel related reward points. So for example, we had a complaint filed here 2 years ago. It was filed against a person who worked in higher education, a person who was responsible for ordering uniforms and supplies for an athletic program. And this person did order from a catalog and acquired some bonus points for the institution of higher education. But then he used those points to buy for himself and for his family merchandise and things of a personal nature. And that resulted in someone filing a complaint here with the Ethics Commission. And the commission and this person entered into a settlement, which we call here at the commission a conciliation agreement. And the person agreed to pay a fine and to endure a public reprimand and undergo training. All right, so I've got a couple more examples of instances of using public office in violation of the private gain provision. This was a complaint that was filed about 7 years ago. And in it, an administrator at a high school, a county high school, who was a P card holder, she bought chair covers and decorations for school events. That was part of what she did for the school. But in one instance, she charged $550 for table covers and chair covers for her own wedding. And then she returned the goods to the school, claiming that they were for the school all along and that she was just borrowing them. Well, the Ethics Commission didn't believe that, because the color scheme was for her wedding, of which we saw pictures, and not the school's colors. So in the end, she also entered into a settlement agreement and received a public reprimand and a $2,000 fine. And this is a really crazy misuse of a P card that happened back in 2015. And this case actually went to a public hearing. And this person was found to have violated the Ethics Act and was given a $10,000 fine by the Ethics Commission. And what happened was the county assessor, used the credit card and P card for his own personal use. He charged almost $50,000. He went on a shopping spree and bought all kinds of things for himself. One thing included a motorcycle. I think it was used still. And this, we have an example. This was also a settlement or a conciliation agreement resulting from a complaint that was filed. This complaint was filed against a circuit clerk. And this is an example of using the prestige of your office for your private gain. And in it, the local police were called to the circuit clerk's house. There was a disturbance of some sort that was reported, and the police went to the house, investigated, and decided to arrest the clerk. And the clerk tried to convince the arresting officers not to take him to jail. And he said things like, "You know, I'm the circuit clerk." And he made some rather vague threats to retaliate against the arresting officers and their local police departments. And as I said, this resulted in a conciliation agreement where the clerk agreed that he violated the Ethics Act and agreed to pay a fine and undergo training. The next area you want to be on guard for is nepotism. And nepotism under the Ethics Act means favoritism shown or patronage granted in employment or working conditions by a public servant to the servant's relative or person with whom they live. So who is a relative? Relative is defined. I have it written there on the screen. Spouse, parents, brothers, in-laws to the daughter-in-law, son-in-law degree, grandparents, those are considered relatives under the Ethics Act. Now, your agency may have a different definition of relatives and a different nepotism policy that might be more strict than the Ethics Acts. So if you need to follow a policy that's more strict than what I'm going to tell you today, then you need to follow your own policy as well. And the rule for nepotism is that a public servant may not directly supervise or participate in decisions affecting the employment and working conditions of a relative or person they live with. That's the rule. And just last month, we took up a new nepotism case. And in that case, a prosecutor asked whether she could hire spouses to work as assistant prosecutors. And in that case, the assistant prosecutors worked in different areas. One was a juvenile prosecutor, one was a felony prosecutor. Neither had supervisory duties over the other, and neither was involved in the hiring of the other. And under those conditions, the Ethics Commission said that that would be fine. That did not suggest a nepotism situation, and that the prosecutor could hire spouses. Another area you want to look out for with the Ethics Act is unauthorized spending. Now, the Ethics Commission has limited involvement in this area, but the Commission could become involved if there is unauthorized spending that results in unauthorized private gain to a person. And this is an example of when the Ethics Commission weighed in on whether a way to spend money was authorized. And in this case, a public agency asked whether it may use public funds to purchase coffee makers or refrigerators for office employees. And the Ethics Commission said, yes, that would be fine. And that is because although there is certainly a private benefit to public employees in doing this, there's a greater public benefit to the public agency, in that the employees can stay close to the office. They're more accessible for the supervisors. So even though there was private gain, that private gain was overridden by a public benefit. Another way that the Ethics Commission weighed in on spending public funds is through its employee recognition and retirement events guideline. And this guideline permits public funds to be spent in the amount of $25 per employee per year for things like events and recognition. And if you're celebrating a retirement event, then in addition to that $25, you may spend up to $100 of public funds for the retiree for a plaque or other commemorative item. Now, if coworkers want to bring gifts or spend their private money, that's fine. These limitations only apply to spending public funds. And here's another here's another advisory opinion the commission issued regarding the authority to spend public money. And the commission said that as far as the Ethics Act is concerned, if a county commission determines that there's a greater public benefit than there is a private benefit, then it can spend money of its public funds on a project. So in this instance, the commission said that if the county determined that building a proposed water line project benefited the county by promoting tourism or economic development, then using ARP funds would not violate the Ethics Act. Public endorsements. Be careful not to make public commercial endorsements. So if one of your vendors wants you to fill out a survey and say how satisfied you are, to rate them 1 through 5, you want to be careful not to do that. That could violate the Ethics Act. And here is a case from 2015. It's an opinion where the Ethics Commission answered in the negative this question: may public educators appear in a software vendor's promotional video and articles demonstrating how West Virginia teachers and students use the vendor's products? Again, the answer was no. That was not permissible. It was seen as mostly an endorsement of the vendor and provided only little benefit to the school system and the teachers. We do get lots of questions about whether public employees may run for and hold public office and whether there are any limitations. Last year, the Ethics Commission took up an advisory opinion where it found that a county commission employee may be a candidate for and hold public position of city council member. The only restriction being that she may not campaign while she's actually working for the county. She may not use county resources, obviously, to further her campaign. And this is, the Ethics Commission has taken up a series of similar questions in the past, and it has always said that, as far as I can remember, always said that the Ethics Act doesn't prohibit public servants or public employees from holding a public office in most cases, but there are other laws out there that might. So even if the Ethics Act isn't an issue, other laws might be an issue. For example, just last week, the Ethics Commission took up 2309, and the question was whether a legislator may work at a state college, which obviously receives state funding through the legislature. And the commission said that's fine under the Ethics Act. And to take it a step farther, the legislator did not need to recuse himself from voting on legislation or appropriations to that college. And that's because it was an appropriation to a public employer rather than a private employer. And if you look closely at the wording of the provision, it only applies to private employers. Okay, but there's a caveat in that. There is a constitutional provision that the Ethics Commission does not have authority to weigh in on. So whether that could prohibit this, the legislator needs to research elsewhere. All right, the next section of the Act, we are using public office for private gain, and we're talking about gifts that may be restricted or prohibited. The general rule is that public servants should not accept gifts valued over $25 from an interested person. And an interested person is a lobbyist, someone who does or wants to do business with your agency, someone who is regulated or controlled by your agency, or someone who has a specific financial interest which you could affect. All right, so there are exceptions to that rule. And the first is the meals and beverages exception. And it says that you can accept from any of those folks, let's say a vendor, a meal and beverage. If that vendor is present with you, you can accept that meal even if it costs more than $25. And again, that's an exception to the prohibition in the rule. If you're going to use that exception, make sure that the vendor is present with you rather than just giving you a gift card or something like that for you to take your family. That would be a prohibited gift. Ceremonial gifts, private gifts, they are not prohibited or limited under the Ethics Act. Now, your own agency may have rules that are more strict and may say, we don't like the optics of any of our employees accepting any gifts from any of our vendors. That's a legitimate rule. It's more strict than the Ethics Act. You'll need to check with your own policies. The Ethics Act also prohibits charitable solicitations unless the solicitation is for a charitable purpose. And the Ethics Commission has probably 100 different advisory opinions that explain what is and is not a charitable purpose. And they're all on our website. And just speaking briefly about our website, all of our advisory opinions from 1989, which is when the Ethics Commission began, are on our website, and they're indexed with a brief summary. So if you want to know about charitable solicitations, you can go to our index and look at solicitations, and it will have every advisory opinion in which the Ethics Commission has discussed charitable solicitations. And again, an agency may have stricter rules than that of the Ethics Commission and Ethics Act. And this is a case, an advisory opinion that was just taken up last week. And the commission held that city officials may solicit donations for the city's free outdoor concert series held in its amphitheater. And they may use GoFundMe or similar crowdsourced funding to do this. And there was a note there that, there might be special soliciting rules from the auditor's office that a public entity might need to be aware of, but that's not something that's enforced by the Ethics Commission or under the Ethics Act. The next provision, relieving gifts, is the public official's name and likeness limitation. And the rule is that public servants may not use public funds or other public resources to display an official's name or picture for the purpose of promoting a public official or a political party. Now, this does not prohibit the use of names of an official's name that would be used in a normal course of business on things like letterhead, signatures to letters, envelopes, educational materials, certificates, things of that nature. You can still use the public official's name. Now, this law came into existence, I believe, last year in 2022. And this is outside of the Ethics Act, and it's not something enforced by the commission, but it is something to be aware of. And it's a law that prohibits state, county, and municipal entities from dedicating or naming any public building or structure for a public official who is currently holding office. So don't allow any of your structures to be named after someone who is currently in office. After they leave office, this statute goes out the window. The next big area of the Ethics Act that we're going to talk about is prohibited interests in agency contracts. And the general rule under the Ethics Act is that public servants may not have a financial interest in a public contract under their authority or control. So public servants, for example, let's use the example of at the city level. So city council members are public servants that have authority and control over all city spending, whether it looks like a contract or whether it's going to a gas station and filling a gas tank. All of that is considered a public contract for purposes of the Ethics Act. So a city council member can't sell gas from his or her gas station to the police department in the city. That would be a prohibited contract because the council member has the authority or control and the financial interest in the gas station. Now there are exceptions. The first is there is a $1,000 threshold, which in our example would allow the council member to sell the city up to $1,000 in gas. Now, of course, the caveat is that the city council member would need to recuse herself from all dealings on behalf of the city with the gas station. Another exception is the part-time appointed exception. And this would apply to the board members that the city council fills, the members that fill the boards at the city level. Those board members actually could have contracts with the city. Again, they would have to recuse themselves and not be involved in representing the city in these contracts. And third is the public employment exception. The prohibited contracting provision specifically says that it does not prohibit any public employment. So, continuing with our example, a city council member may hold a job with the city. Again, then that city council member would need to be recused from all dealings with his or her employment. Okay, now this is another prohibited county contracts provision that is interpreted but not enforced by the Ethics Commission. And that is because it is a criminal statute. And this applies to county officials. So any county officials out there, please listen, and you can disregard most of what I just said about those exceptions, because none of those exceptions apply to this provision. And it says that county officials are prohibited from having a financial interest, directly or indirectly, in a contract, including employment, over which their public position gives them voice, influence, or control. So this provision has been interpreted broadly by both the West Virginia Supreme Court and the Ethics Commission. And it's broadly interpreted the term voice, influence, or control. And I'm going to explain that in just a minute. I'm going to give you an example. But before we get to the example, I'm going to tell you about some exceptions. And they include that spouses may be employed in the public school system as principals, teachers, and service personnel. Also, licensed healthcare providers at government-owned hospitals. So spouses can be employed there. We just earlier this year took up an advisory opinion where the commission said that a county commissioner's spouse may be employed by the county ambulance authority as a licensed emergency medical tech or paramedic. And that was due to this exception that we're talking about here, and that's for spouses. Also, another exception, county officials may work for a county vendor, but only if the official is a salaried employee, does not get commissions from sales, and is not an owner of the vendor's store. And county officials and their spouses may work for banks, regardless of whether the county has money or does business with that bank. In 2022, the legislature added a new exception, and it allows county officials to have contracts for goods and supplies, but not services, if the county official is the lowest bidder on a project. So if the county official is the lowest bidder, it may be able to hold that contract if it jumps through a couple more hoops. And if that's, we haven't seen that come up in practice yet. Like I said, this just went into effect in 2022. So we haven't seen it play out in real life yet. Now here's the example that I wanted to tell you about. This is an example of a county commissioner and the breadth of the voice, influence, and control element. A county commissioner, county commissioners and their spouses may not have contracts with or be employed by any county office, even the county offices that have their own elected officials, the assessor's office, sheriff's office, clerk's office, even though they have elected heads of office that are not the county commissioners. County commissioners and spouses still cannot work for those offices. And that is because county commissioners do have some authority over those other departments, in that they approve the budget. The county commission approves the budget for each of those other offices. And the Supreme Court of West Virginia and the Ethics Commission have both said that that is enough to give voice, influence, or control over all of those contracts of those other offices and the employment of its employees. So you can see the breadth is pretty wide there. Another way that a county commissioner would be prohibited from holding a contract or working for an entity is when they have contract or when they appoint members of a board or a commission. So for example, county park board members and building authorities, those members are appointed by the county commission. So the county commissioners can't have contracts with those entities, can't work for those entities, unless one of those exceptions that we mentioned before applies. And then there's a third way. There's a third way that commissioners can be prohibited from working or having contracts with someone. And that is when the commission, the county commission, makes appropriations to an entity, to a nonprofit. And this is an advisory opinion 2023-12 that just came up last week. And in that one, the commission, the Ethics Commission, issued a bright line rule, which is going to help us administer this provision in the future. And the bright line rule now is that a county commissioner may not, and spouses may not have contracts with or be employed by a nonprofit to which the county contributes 7% or more of the nonprofit's budget. So the bright line rule is now 7%. We're going to call that the 7% rule. So we talked about what the rule is, what the exceptions are, an example, and now we're going to talk about the exemption process. So if under either the Ethics Act prohibited contracts provision or 611015, if a public agency believes that it has little other choice than to award a contract to an official, that entity can come to the Ethics Commission and sort of plead its case. And the commission will decide whether there is sufficient hardship or excessive cost that would result. And if that's found to be the case, then the Ethics Commission will allow the contract to go forward. Okay, now we're going to talk about voting restrictions. And the general rule is that a public official may not vote if she or an immediate family member or a business of theirs has a financial interest. And public officials may not vote on a personnel matter involving a relative. And finally, there's a class exception of 5. So if an official would be prohibited under those two general rules, but the vote would affect 5 other people in the same manner, then the public official may vote. So an example is from 2019, an advisory opinion where the commission said that a mayor could vote on a zoning question that involved a hotel developer, even though the mayor's house was in the neighborhood. And that was because the mayor's house was in the neighborhood with 20 some other people who would equally be affected by the hotel development. And there is a special voting rule for nonprofit appropriations. So it's not uncommon, in my experience, that public servants might serve on a nonprofit board or be employed by a nonprofit. So there's a special rule to address how to vote in those situations. And the rule is that if the public board member also serves on a nonprofit, the agency may still make appropriations to the nonprofit, but the member or spouse may not vote if either is employed by the nonprofit or paid by the nonprofit. And if the board member is not paid, he may vote only if he first discloses his employment on the agenda and at the meeting. So there's like double disclosure in that instance. Again, all of this is on our website. So if you get in this situation, don't rely on your memory. Just go to our website and make sure you follow the rule properly. And if you do get into a recusal situation, again, it's going to be on our website. But for today, a public servant who is required to recuse must fully disclose his or her interest, leave the room during both the discussion of and the vote on the issue, and make sure it's reflected in the minutes. Next, we have some employment restrictions, and these apply only to full-time public employees. So anyone who is appointed to a board, this wouldn't apply to. A legislator, this doesn't apply to. These are full-time public employees. And the rule is that they may not work for or buy or sell property from someone who had a matter on which they or subordinate took regulatory action within the past year, or someone who currently has a matter before the agency on which they or subordinate is working, or someone who is a vendor over which the employee exercises control. So we have some post-employment or revolver door restrictions. And the first is prohibited representation. And the rule is that a public servant may not represent a private party in a matter after leaving public service when that public servant worked on a particular matter involving a specific party or that specific party, and the public servant or former public servant personally and substantially participated in that matter. And there is a way for public agencies to consent to waiving this, but absent a waiver, public officials or former public officials should not represent a party in this situation. And next we have the revolving door, and our revolving door is for 1 year after leaving public service. And it applies to all public officials, full-time staff attorneys, and full-time accountants. So those folks can't come back to their agencies and represent a client in most matters before the agency. So for me, for example, if I were to resign for a year, I couldn't come back to the Ethics Commission and represent a client in a contested administrative matter. Okay, we are coming toward the end here of the Ethics Act portion of this presentation. We're going to go right into the Open Meetings Act. Excuse me. And these are just a couple housekeeping matters, really. And the first is filing your financial disclosures. Not everyone has to file a financial disclosure. 3 groups of people need to file, and they are due February 1 of each year. And we encourage you to file them online. And the people that need to file are elected state and county officials, members of state boards, commissions, and agencies who are appointed by the governor, and this laundry list of people who work for the state: secretaries of departments, commissioners, deputy commissioners, assistant commissioners, directors, those same sub-director positions, department heads, and assistant department heads. So it's pretty much a laundry list, and you can see that it goes pretty deep. So even people that may not seem to have too much influence on public spending, like the assistant department heads, they may not even supervise anyone. But if that is part of their title, they need to file financial disclosure statements. Okay, and lobbying contracts. This is a new rule that went into effect in 2022, I believe. And it says that it provides some disclosure requirements for government agencies who hire lobbyists. So if your agency has retained a lobbyist, then certain things need to be disclosed to the Ethics Commission. And you can find that form on our website. And here's another disclosure requirement. It's strictly for transparency, and it requires the disclosure of interested parties on a state contract valued at over $1 million. And that's not $1 million a year, it's $1 million cumulative. So if your agency has a contract of that amount, then this form probably needs to be filled out. All right, so I talked about some settlement agreements, some sanctions, a public hearing, some sanctions that were imposed at a public hearing. And here is the list of possible sanctions that the Ethics Commission can impose. And you can see the fine is up to $5,000 per violation. So these are the main topics of the Open Meetings Act. The first is the meetings that are subject to the act and the meetings that are not subject to the act. what your notice and agenda should look like. We're going to talk about executive sessions, minutes, and violations. So the Open Meetings Act applies to probably everyone who's listening in. All state, county, municipal, administrative, and legislative bodies, and any other bodies that meet the definition of public agencies, like departments and commissions, and also committees, subcommittees of these agencies. Depending on what they're doing, their meetings could well fall under the Open Meetings Act. And under the Open Meetings Act, certain meetings need to be done pursuant to it and done in public. And those meetings are the meetings where a quorum of the governing body meets, let's say city council members, on a matter for which a quorum is required in order to make or deliberate toward official action. So I know that's a lot, a mouthful. And but when these elements are met, the Open Meetings Act requirements are triggered. Now, meetings that are not subject to the act are when you get together with your public body to create an agenda, or when you're taking up an adjudicatory matter, or you're attending a site inspection, a political party caucus, when you are having general discussions, when you're in a social situation, when you are in training today. If a quorum of council members is in the same room right now, listening to this training, that's okay. That meeting is not subject to the Open Meetings Act. Now, the caveat to all of that is while you are together doing these social and unofficial things, you can't behind the scenes actually do business and deliberate toward matters that are going to be on your agenda, let's say, at another meeting. And this is a new advisory opinion from earlier in this year, and it's an interpretation of the Open Meetings Act by our commission. And the commission said that the act does not require a governing body to provide an actual physical meeting place. It's okay not to have a physical room as long as citizens have access to it. Electronic access is sufficient. It can be a phone number where people can call in and hear each other. The members of the governing body need to be able to hear each other, and the public needs to be able to hear the governing bodies speak. If those conditions are met, then a actual physical meeting space is not required. When you have a meeting that's subject to the Open Meetings Act, you have to give advance notice of the meeting. And in that notice, you should include the date, time, and place of the meeting. And again, this is a reminder that sometimes committee meetings are subject to the Open Meetings Act. And public agencies are encouraged to make their own rules about how much notice is needed to be given. But the Ethics Commission has stepped in and filled in the gap for all of us who have not made our own rules. And the Ethics Commission has said that for your regular meetings, you must give 3 business days notice. Unless you meet every week, then 2 days is sufficient. For special meetings, 2 days notice is required. To amend an agenda, you can do that with 2 days notice. And finally, for state agencies, in addition to that, you must notify the Secretary of State's office electronically with 5 business days of notice. And again, this is just the notice, not the agenda that we're talking about, as far as the business days with the Secretary of State's office. And this is just a snapshot of our website where we have our notice for all of our meetings for the whole year. And actually, this is from 2019. But on our website, you can see the current list of meetings that we're going to have this whole year. We do this January, December of every year for the upcoming year. And you can see we have every date because our meetings are held every first Thursday of the month. And then the committees that might meet every month, they're listed there too, the location and the time, everything that a notice requires. We go ahead and take care of it the beginning of the year so we don't have to keep on remembering to do it every month. And we do the same with the Secretary of State's website. Now, agenda, okay, and there's an emergency meeting. Let me just mention emergency meetings. When you have an emergency, you don't necessarily need to give any advance notice. If there's no time to give notice, then that's okay. But be mindful that not everything is an emergency. If you just miss a deadline, if you forgot to pay somebody, the threshold for meeting the definition of emergency is pretty stiff, and it has to be an unexpected event that could result in imminent threat to public health or safety, damage to property, or loss, material financial loss, or other substantial harm. So you should not use an emergency meeting as part of your regular course of business. Now we're going to talk about the meeting agenda. So we talked about the notice, now the agenda. Now the agenda is not something you can probably do a year in advance because you need to be very specific on your agenda entries. The test is that the entries need to give reasonable notice to the public of every issue to be discussed. Every issue to be discussed. A reasonable person who's not intimately familiar or at all familiar with your agency should be able to pick up your agenda and be able to figure out what it is you're going to be talking about. So topics like old business, new business, personnel, approve a contract, those are too broad. They don't tell the public what it is you're taking up. So instead, you should be more specific and say things like filling position of office manager instead of just personnel, or opening sealed bids for City Hall roof repair project. And in 2023, in this regular legislative session, was passed the Uniform Public Meetings During Emergencies Act. Now, this is something that you will need to discuss with your agency attorneys because the Ethics Commission was not given any authority to interpret or advise on this Open Meetings Act. Now we're going to talk about executive sessions. We always get lots of questions about executive sessions. So here are some bullet points. You may only go into executive session for reasons permitted by the Act. And your agenda need not indicate that something will be taken up in executive session, but it does need to mention the item itself, and then it's going to be taken up. For example, hiring new executive director. That would need to be on your agenda. The fact that you expect to go into an executive session does not need to be on your agenda. To go into executive session, the formality is the same as with any other motion that your public body makes. You make a motion, second, vote, however you typically do it, and you go from there. And you take your vote, even though you discuss it in executive session, and maybe you kind of come to an informal understanding of how everybody feels, you take your official vote in public after the executive session. And these are some reasons for the session, executive session, to consider personnel matters of a particular public official or employee. So if you're talking about across the board raises, that's not appropriate for executive session. Matters involving war or security. Matters involving commercial competition, which, if made public, might adversely affect the public agency. And to discuss matters which, by express law, is rendered confidential. So getting advice from your attorney is a good example of something that will fall under that category. Last year, the commission passed or issued an interesting advisory opinion. And the commission said that the act does not make information discussed during executive sessions confidential. Now, what is the grounds for going into executive session is confidential. But while you're in executive session, don't make the mistake of thinking that the other people there are bound to not repeat what you say in there that's not confidential. All right, well, we are rounding out our presentation here. We have 2 more slides. And this slide's about minutes and what your minutes should look like. Of course, you need your date, time, and place of the meeting, the name of each member of the governing body present and absent, all the motions and resolutions and et cetera, and the name of the person proposing them and their disposition. And if you have a roll call vote, you need to specifically identify everyone's vote. And this is an example of our minutes, and these can be found on our website. All of our minutes and agendas are on our website. I will note that that's not required by the Open Meetings Act. The Open Meetings Act was passed in the 70s, I think. Yeah. And so, of course, this electronic publication was not a thing then. So, but nonetheless, I'm seeing more and more and more and more that public agencies do publish all of this on their website. And for transparency reasons, I certainly encourage that you do that. Your minutes must be made available within a reasonable time after they are approved, not when they're still in draft, but after they're approved. And here is a slide on violations. If someone were to violate the Open Meetings Act, if someone could file a complaint in circuit court, not with the Ethics Commission, because the Ethics Commission only has authority to offer interpretations of the act and to give people immunity when they follow our interpretations. But a citizen needs to file a complaint actually in circuit court. Okay, that is it